On behalf of the KL Chair in Criminal Law and Center for Criminology and Victimology at the National Law University, Delhi, I extend very warm welcome to all the guests and dignitaries who have joined today for this panel discussion on wrongful prosecution, legal remedies, based on the report 277 of the Law Commission of India. Friends, while I extend the heartiest welcome to the panel, distinguished members of the panel, especially I thanks Mr. Honorable Justice Ravi Tripathi for your time. I also welcome Mr. B.B. Pandey, the distinguished professor at the National Law University, Delhi, and our guests who have to join. I just mentioned that Mr. Siddharth Luthra is, he has, he's coming from some far off place and just he has landed, I think, a couple of minutes ago, and he's already on the way to join. And of course, Gordon is also coming. And so I welcome all, and of course, our Vice Chancellor who has taken all pains to come, despite the fact that he has just landed at 5 o'clock in the morning, coming from US, and I said we can spare you, but he insisted that we would be very happy to join. Friends, a little background before we actually start this panel discussion as to why we are doing this and what are the important reasons to organize this small activity. I also welcome the students, LLM students of National Law University, Delhi, and other law colleges who are represented here, and also the PhD group and other persons who have joined the distinguished guests. I welcome Professor Vani also, who has taken time out to come, and friends from Innocence Network, Sharif and Sohail and Sharik and Shashank. So many friends are there. They are all the partners to this work that we are doing at the National Law University, Delhi. Friends, the issue of wrongful prosecution came before the Delhi High Court in the case of Bablu Chauhan versus NCT of Delhi, 2017, where the matter, there were 3 issues before the court. One was about fine, and there was also about the suspension of sentence and wrongful prosecution. The Honorable Court contacted the National Law University, Delhi to assist in the matter, especially relating to the suspension of sentence and the recommendations relating to the redressal, especially in terms of compensation or other kinds of assistance which could be conceived, because the realization at that point was that there is no law relating to the people who get exonerated on account of their acquittal after serving a couple of years in the incarceration. And therefore, the whole issue came in the form of a report which was submitted by the National Law University, Delhi, where I acted amicus before the court, and we submitted the full report, which is available online also, and I have circulated it here also. So friends, the report cited the case of Kashmira Singh, where the Supreme Court discussed the problem of wrongful prosecution. It said the practice of not giving bail and not releasing the accused, especially in case of life imprisonment. So in theory it appears to be good, but the problem arises when we see that in reality the appellate court takes several years to decide this kind of appeal, and definitely some unwanted incarceration takes place. So the fact remains, the operation and the application of Section 389 is something which was the whole question. Why and how it can be invoked? Because I'll discuss, I think I'm not discussing all the things which are required to be discussed, because I leave it first to the analyst and then probably we will do this. But the idea of this report, the reference was made by the Delhi High Court for the Law Commission to work out a framework of compensation and assistance to the auxiliaries in wrongful prosecution, and what kind of mechanism could be evolved whereby these people could be compensated, because there was a consensus on the fact that eventually these people tend to suffer several years on account of, but the point which was being made in this report was quite delicate. It's not unlike what we have seen in Adam Bhai, in Akshardham, in other cases, where we find the terror cases, couple of years they tend to pass and afterwards they are exonerated. Here the question was why the section 389.1 and 389.3 was not being invoked. That was the main issue. So this is a very small reference which was not a very larger question. Larger question is of course the way the wrongful conviction and wrongful prosecution is treated elsewhere in other jurisdictions. This report talks about the status of wrongful conviction and wrongful prosecution in other jurisdictions, especially in the UK where the Criminal Justice Act, and in the US, a lot of arrangements are already available. So question is that what is so important in our context, what could have been done? So this report is kind of answer before us. But several things are extremely important as far as this report is concerned. The first thing being that it is first time that the term wrongful prosecution is being institutionalized in the criminal jurisprudence. This is a great realization or a great recognition to this particular expression. Secondly, the thing is that the liability for paying the compensation was also placed on the state, like in other. But there are several issues which need discussion, and we have flagged those issues as to what is the Law Commission's approach to use the term wrongful prosecution, malicious prosecution, miscarriage of justice. So these terminologies have been used interchangeably. That is first thing that we notice. Another thing which we notice is the standards of wrongful prosecution which have been provided. And apart from that, the complete missing out of the section 389 in the report. I am not dwelling on into probably at some other stage. And the last thing which I would say, and probably I'll request the Vice Chancellor to welcome. The last thing is the methodological critique of this report. How the report has been done, whether it has followed a real method of study and research, how the conclusions have been arrived. That is something also which probably our legal lenses tend to overlook oftentimes. But this is one very important concern for me, because at page 9, para 1.19 and para 1.20, the report is talking about the methodology. I think this can also be one of the areas where we can pay some attention. So taken together, what I am trying to understand through this report is some of these questions. So, and also we want to understand that where is the burden, like this report is also talking about the constitution of creating some special code for the realization of compensation. So does it not really place the burden of proving the misconduct or malicious prosecution on the part of the victim? I don't know, it is a very difficult proposition because the definition of wrongful prosecution in the report constitutes very important, that it has to be malicious prosecution and prosecution instituted without good faith. Now, who will prove these two points? That is also something. So probably it looks that as if a whole lot of, again, legal battle emerges for the victim to realize. I am not clear, probably the discussion would throw light. We could have thought of something more simpler. Can't the court at the time of deciding the suspension of sentence or giving the bail, some solace or some grant of compensation was really something, could have been a very simple way to address this particular issue. Also, lastly, which the panel may like to consider the issue, is that the report, the whole discussion, because here the representative of Innocence Network are also sitting, that when we have been engaged with this issue, and the core point was that the whole, lot of providing the remedies to these people was the requirement to recognize certain rights of these people. Now, this is not a very right-based formulation. Probably it looks a very charitable kind of proposition for me, because this report really does not talk about that what are the rights of wrongful prosecuted persons which should be addressed in terms of providing compensation or assistance. So recognizing right could have been the first thing, and the remedies could have emerged from the rights themselves. That is another thing which I think. So several issues, probably we can discuss those things in the course of time. At this stage, may I request Mr. Ranveer Singh, the Vice Chancellor, National University, Delhi, to say a few words to welcoming the families.
Yes, so nice. You will know that, as you said in the beginning, that I came in the morning, and he said a few words. Thank you very much, everybody coming to the program, and we can start with the parents. But that is not going to happen. Actually, the entire focus on victim justice, I must thank Dr. Vajpayee for activating the whole debate and doing a lot of work on this subject. I'm no expert on the subject, as I'm by default mentioned in the list of panelists, because my job is to welcome you all. I don't know how many of you are especially students by choice here. I'm sure not for attendance, because not bullied by the staff that if you don't come, we are going to create problem for us. Please don't come to programs if you are not interested. Come to programs you are interested as an academic. I came because I was interested, not because the star invited me. Right? These are very, very important things. And for us, the motivation is people like Justice Tripathi, Professor Pandey, Varinda Grover, they're all very busy people. My only qualification to speak to you this morning is I was the part-time member for the 19th Commission of Ethics. And the second was I was deeply sensitized and felt concerned when I met Azam Bhai. Azam Bhai came to NLU Delhi, and I don't know how many of you were there at the time in the hall. The hall was full, all faculty, students, and we wanted to know what happened to him. We wanted to know what happened to him. He narrated the whole story. After 12 years, you say you are innocent, you were framed, and he told us how the entire family was demolished. The children were turned out of the school. And what kind of torture and trauma the family must have suffered, it was anybody's guess. I happened to meet after that time one of the very senior judges of the Supreme Court, who became the Chief Justice of India, in ILI or a selection committee. I said, sir, what happened? Why the compensation was not given? What happened to 142? What happened to complete justice? You are that article, wonderful article. What happened to complete justice? When they pass a decree, they have to ensure it's for the court to give a complete justice. But if complete justice was done in this case, so all these issues, and then for students of law, you must be thinking what we can do. हम क्या कर सकते हैं? The students, how many are students of 5-year course? And then PhD students, right? Do you know what the students of NLU students did in the other Mike's case? They immediately sat down and said, let us find out what we can do. And asked him what kind of profession you would like to take up to recreate your family and to re-establish yourself. He said, probably I will take up dairy. Buy some buffaloes and some milk business. And then we asked him how much you require. He said roughly 5-6 lakhs students of New Delhi launched an online campaign. Within 1 week, I think roughly 10 lakhs were collected. Given to him. And the life started. And for a state, what is 10 lakh for a state? What is 10 lakh for a state? Why it can't be done? So the big question is the whole issue of victim justice, compensation is very, very central to the whole debate. And it's very timely, Vajpayee, you have taken it up. We are talking about a lot of things. And I remember when we launched the death penalty report, which was launched by Justice Lokul, I said, we are not looking at only death penalty issue. We are looking at the whole failing criminal justice system per se. See, me and Aparna being the part of the UPR system, the Universal Periodic Review 1, 2, 3. And when we deal with these issues and we look into these issues, we see criminal justice system failing every day at all corners. And the kind of prosecution system we have, the way we select our prosecutors, all ad hoc people from somewhere, no proper selection, no proper training, nothing, right? And another part was that I was also the part of the Soli Swarajya Committee to look into the police reforms. And we have been saying it for ages, We have been saying for ages, let us separate law and order and prosecution. For castings guidelines, how many times Model Act was framed, again another committee, Kamal Kumar committee was appointed, I was also there. And we found that we were looking into how many states really complied with the guidelines issued by Prakash Singh's case, and when the Model Act was framed by different states, because it is a law and order also is state subjective. We can't do, center can't impose a law on the states. And believe me, it was only Kerala, state of Kerala, and where only 20% of the guidelines of Prakash Singh's case laid down by the Supreme Court were carried out. None of the states, none of the reforms. Again, the Supreme Court looked into it. Kamal Kumar committee was appointed, right? And it is now the draft is pending with the Home Ministry for the last, I don't know how many years. We did our job, but it's still there. But the question is, are we serious? But in the process, somewhere you see miscarriage of justice happens, right? And somebody said, if law is not justice and justice not law, states are nothing but great rubber bands. What the states are for, if they do not deliver justice to the people. And I remember a small incident where in US, the car of a judge, the federal court broke down. And he got down and said, they are very informal people, and he stopped a cab and said, will you take me to the court of law, the other side of the road? The cab driver looked back and said, do you want to go to the court of law or the court of justice? The judge said, sorry, I want to go to the court of justice. For a common man, it's not a court of law. Otherwise, ADM Jaipur will happen, which you saw in the 2 days back. Again, revisiting ADM Jaipur in this activist cases. Are we going back to ADM Jaipur cases? The days, right? The whole issue is this. As a democratic country, and when we go abroad, people have so much of respect for India. Actually. And we have to be very careful what we are doing in terms of criminal system. How long I don't know where you take center when you go to the next UPR. I don't know whether I'm there or not by the time. But Aparna, how would you say that why the torture duty is not taken care of? Every time we say it's with the parliament.
No, even the law
Next time we say it's with the law commission.
No, law commission.
Even the law commission has given it.
They have said make a law.
Make a law. And then we say now we are making a law. How long? How long? So we have been putting all these problems somewhere under the carpet. And time has come to squarely face all these problems and find a solution. And the next generation present here is important because you need to be worried about what is happening to criminal justice system. You see Delhi day in, day out what is happening and how unsafe you feel. So the whole exercise is in relation to actually the entire question of how to come out of this serious crisis, the whole criminal justice system being at the crossroads, and victim justice compassion, whatever we call it, is a part of it. So probably with these words, I not few words, but I thought I can share with you that they are very serious and very serious, deep concerns where everybody will ponder over it. Thank you, Vajpayee, for putting in this case.
So thank you, sir, for placing the whole discussion into a perspective, and it becomes very relevant because 277 report has also suggested the amendment bill where they intend to create chapter 27A and also amend the section 365. Now, all these things are very important food for thought to the law researchers, because the idea of this panel is also really, I quickly organized thinking that we should not repeat the mistake which we had committed when 357A was being introduced, because those things still continue, because that compensation scheme also came after long struggle that the victimologists, neurologists and all activists have been doing. And the idea was to bring a legislation which could be exclusive, like in England and other places, Victims of Crime Act, like in the US. But somehow it was implanted in the CRPC 357A, and lots of states are still struggling. Of course, I must congratulate the Delhi, Legal Service Authority. They have taken it up, but Delhi is not the only place in India. But by and large, a lot of things happen the manner in which it, these things are taken up. So therefore, this is the best time to look at. And so I would really now like to throw this subject open with the Wrongful Justice Triparthy to initiate the discussion. And we welcome Siddharth Luthra-ji. And he had a very long day for today. I'll narrate this story about his entire travel. It was very adventurous, and you'll never be able to amaze it. But I must thank you really for your time today. And so I think with this, we'll have very short time today for the panel. So 15 minutes probably for each panelist, because some interventions will also be there and some discussion. So we'll again have the opportunity to respond to the discussion from the floor also. So I would first request Honorable Justice Tripathi, who is the part of the. I will make yes. I'll allow. So since Justice Tripathi was the part of the Law Commission and part of this report, so I thought it very apt to have him on the panel. So we'll begin with your views on the report and the future that we may have on this particular issue. So how do you look at the whole issue, the whole report now in a fresh context? And of course we'll discuss certain issues. There may be here and there some criticism also, but I think we'll take them in a right spirit. So over to you. Thank you.
Very good evening to everybody. Friends, I don't know why I'm asked to speak first. Because our work is already before you. And in fact, it would have been more fruitful if the commission would have continued and had an opportunity to revisit our own report. That is out of question. And it's not required to be told to this gathering that report of the Law Commission is always in a recommendatory form. Right. Maybe that report may not be up to the satisfaction of everyone. I'm quite sure that it may not be. But at the same time, what I feel is it's a good beginning and in a good, correct direction. That is what I feel. And any discussion which takes place here, only thing which I can do is, in addition to you people, putting it before the next law commission when it takes up the similar issue or the same issue, I will also be putting the discussion outcome from here to the law commission. That is the best I can do. Otherwise, if some particular point you feel like discussing with me, I'll be very readily doing that. There is no difficulty on that. Otherwise, chapter 6 of our report, you will find that conclusion and recommendations are already made there. In fact, when we were thinking about that, what should be the remedy available to a person who is already subjected to some wrong, we thought of two things. One was, it is our experience that to bring a fresh law or a standalone law, there are more difficulties than the amending the present law. That is one of the consideration. Maybe that our assessment is not right. You people can judge better. But then that was our assessment, and that is why we thought of, instead of undertaking the exercise of putting a standalone law, we thought of suggesting certain amendments and inserting maybe as a good beginning for this particular purpose. Now the difficulty with this wrongful prosecution and malicious prosecution is concerned. I am of the opinion that wrongful prosecution and malicious prosecution may not be exactly interchangeable terms. May not be exactly interchangeable. Because when you talk about wrongful prosecution and malicious prosecution, there is a basic difference between the two. When you talk about malicious, the mens rea, which is one of the very well-known concepts in the criminal law, is supposed to be there. And then only you can say that there is malicious prosecution. Reasons may be different. Reasons may be, in variety. And for those variety of reasons, a particular person may suffer a malicious prosecution. Possibly this is not an issue which can be tackled only in this narrow sphere. As Vice Chancellor Ranveer Singh was rightly referring to, we need possibly at the most urgent basis the reform to the police mindset. I don't know, you all are very alike people, so you must have read. Only day before yesterday or so, an executive of Apple driving in a car and is shot dead. Not under any mistaken identity. No, not at all. I don't know what offended those two policemen to the extent that they took the entire law in their hand and not only investigated the thing, not only prosecuted the thing, not only pronounced judgment, but even executed the whole thing. Just in front of the car, and then you stop the vehicle and then fire at the person concerned, and then you say, I don't know how far it can go down to the anybody's throat, that it was a self-defense. What self-defense? You are firing at a person who is totally unarmed, and in that situation you are saying that no, he was that was an act in the self-defense or something. Now, if that is the mindset of the police, possibly what is required is that, and until that is changed, I can only tell you one thing, that wrongful prosecution or malicious prosecution are not going to come to an end. They will continue until you change the mindset of the police people, and then only it can be done. The certain definitions we have tried to incorporate by amending the section 2 of the CRPC, of course very few of them, so that these new concepts are there, and it may not be said that where it is defined. Normally what happens, when we go to the court of law, the court always asks, so where is the definition, or what is the definition, and what are the ingredients for that? And that is why we tried to incorporate malicious prosecution, also wrongful prosecution, and then we have tried to provide a remedy by insertion of chapter 27A and providing certain procedural part also, that this is how a person can go for the remedy when he finds this. Professor Bajpai rightly referred that by providing this remedial method or procedure, whether we are able to give direct relief to that particular person who is already wrong, answer is prima facie no, because he is then supposed to prove that he was wrongfully prosecuted or maliciously prosecuted. Friends, the difficulty is until you are able to establish that it was a totally malicious prosecution. Now for that there are two possibilities. One, the court itself records the finding. Well, then those findings will be to the help of that particular wrong person, and then that can be the basis for his filing the application and seeking the compensation. So I will wait for the other panelists to express their opinion, and then if required, I'll try to express again my views on that. All right? Thank you very much.
So thank you, sir, for putting these things together, because these terminologies are really very important in how they are going to shape in the arriving jurisprudence in criminal law especially. And because already the miscarriage of justice was in discussion and oftentimes it is used, but this wrongful prosecution and that too the bracketed miscarriage of justice on the title of the report, so sort of difficulty at the moment, and therefore, but it is good that you have clarified a lot of things and we can surely get back to you. Professor B.V. Pandey is with us actually, so I don't think any introduction is required. He's one person who gives us a lot of exciting ideas whenever we are faced with some issue, and it was great to discuss this report with him, and I requested him, and he is again today, he is arriving all the way from Lucknow to join this discussion. This is the spirit and this is his commitment, which we always salute, sir. And you are a true and living inspiration to young law student and researcher, and we learned a lot from you, and we thought that your ideas on this issue will be very useful. So, sir, I hand over to you. Please.
Colin, take his seat.
So I'm happy that we complete the panel. Yeah, so Colin is now with us. And so over to Mr. D.V. Pandey.
Thank you, Professor Bajpai. Justice my left and Siddhartha on my right, and Colin and Ranga, and the students here. Professor Bajpai asked me to speak on this the Law Commission 277th report. I thought let me present it little differently. Speech, thought and silences relating to wrongful prosecutions. It is full of silences and less of speech and less of thought. But when I use these three terms, speech, discourse, is the discourse that has taken place through authoritative rulings of the court. I am underscoring only two rulings. The Adambhai case, which has become landmark, not only for the facts, but for all that happened, the kind of gross wrongfulness down the line, in which the state was complicit, The police was complicit, the prosecution was complicit, even the judiciary was complicit. Para 222 and 223 of Justice Goda's judgment say that the judgments were erroneous and were full of error of law. Para 223. Therefore, it is down the line. And 6 persons suffered unlimited. And what the Honorable Court spoke, the best part was Justice Gopal Goda concurring Justice Patnaik acquitted all the 6. But on the question of compensating the persons who had lost 10 years or suffered innumerably, the court, Justice Goda, didn't exercise his powers under 142. If you want to do complete justice, you should have exercised your powers under 142 and given justice. You say innocent persons have been roped in and real culprits have been spared by the police. And to cap it all, when independent petition for compensation was filed by Adam Bhai, Justice Deepak Mishra at that time, I think he was not CJ at that time, he said that if every acquitted person is given compensation, it will create a dangerous precedent. Dangerous for whom? For the state, dangerous for whom? For the exchequer, dangerous for the accused, or for whom? The victim. Now, dangerous precedent. This was the end of Adam Bhai's story, which must come back to you whenever you talk of wrongful prosecutions. And then in the second case, which I have taken for speech, is again in the compensation dangerous precedent. Judgment was Justice Mishra, and in Nambi Narayan case, decided on 15th September, again Justice Mishra, Chief Justice Mishra, by now. Nambi Narayan suffered wrongful prosecution at the hands of Kerala police, Kerala government. Nothing as compared to the kind of horror story, because Nambi Narayan was in custody for 50 days only. 45 days CBI custody, 5 days police custody. And then he was acquitted in 1998. But in this case, Nambi Narayan case, the Honorable Supreme Court Justice Deepak Mishra again, Chief Justice Deepak Mishra, used the public law remedy flowing from Article 21 and gave a compensation of 50 lakh rupees. The Kerala government will pay a compensation of 50 lakh rupees. And ordered, set up a committee under Justice Jain and asked the state government and central government to give one nominee each to find out the complicity of all the officers in getting a false case. Now, it seemed to be complete justice. But in Naminarayan also, the court said it is not a case where accused is kept under custody and eventually after trial he is found not guilty. Para 31, Justice Mishra, Chief Justice Mishra says this. Now, he seemed to be sounding the same caution of dangerous precedent of 2016 compensation petition of Adama. Now, what is that kind of cases in which your Lordship wants for wrongful prosecution also no compensation should be given? Are there some special cases, or that core seems to have dissolved in the meantime? Whether it is because one was Gujarat government, the other is Kerala government, or it was an incident of 1994 and it was an incident of 2002. Is it because dangerousness varies with the state involved? That is a moot question that has to be explored. But you must keep in your mind the speech discourse, always when you are discussing the thought discourse. The thought discourse is the Law Commission's 277th report. The thought discourse is that you have given an idea. It will be recycled, it will be cut and pruned, it will be suiting the government's fancy, and the thought discourse itself has some of the points on which the Law Commission has done a useful job. Out of the 6 chapters that they have broken this report in, Chapter 5 pertaining to standards of miscarriage of justice. The standards of miscarriage of justice, and as they have said, the Western standard is too exacting for India. It doesn't work. Wrongful incarceration is too limited. Therefore, we must invent a new word, wrongful prosecution. In Western standard, in Q with Article 14(6) of the ICCPR, it says that if a person is convicted and then later on facts are found which prove his factual innocence, then he will get the benefit. Only those persons. Here it is the reverse. A person suffers first and then he is acquitted. The long period, Jalil Ansari case, 2016, he was inside for 23 years. People have been in custody for 23 years. His whole life. Adam Bhai was 10 years. Jalil Nasiruddin was inside for 23 years. Now, the question is, what should be, and the Commission has done a useful job by saying, but here also, at para 5.17, you have wrongful prosecution, as noted above, are cases of miscarriage of justice. When procedural misconducts, police or prosecutorial, malicious और negligent, negligent एक बार गलती से आया है क्या, या आप लोग जानबूझ के रखना चाहते थे? Now हर बाकी जगह कहीं negligent नहीं आया है, क्योंकि आप malicious ही दिखाना चाहते हो. Now यहाँ अगर negligent आ गया, तो मैं चाहता हूँ negligent हर जगह होना चाहिए, क्योंकि for the person who has suffered, whether it is malicious or it is negligent, it is misfeasance or non-feasance, it is all the same. अगर उसकी दृष्टि से देख रहे हो, then both ways it is negligent also should be included. Now in para 6.10 in the recommendation, now let me skip that. In nature of proceedings, in para course of action, cause of action and nature of proceedings में, they have used the word nature of proceedings, recommendation nature of proceedings में,
Page number 87.
page number 88. Nature of proceedings में, the Law Commission is saying the burden is on the claimant, the accused, to prove misconduct. Burden is on the accused. He is not an accused. He is victim of abuse of justice. Now with burden on the claimant of wrongful prosecution, the burden is on him to prove that wrongful. हमने क्या wrongful किया ये तुम बताओ. अरे तुमने wrongful किया, तुमको मालूम है, हमसे पूछ रहे हो हमने क्या wrongful किया. अरे रेफरेंस का लॉकेटर लगना चाहिए तुम्हारे ऊपर. तुम्हारे पास सारी मशीनरी है, तुम्हारे पास सारी व्यवस्था है, और हमसे तुम पूछ रहे हो हमने क्या wrongful किया, हमने कहाँ चाबी घुमाई नंदी नारायण को फंसाने में. अरे ये तुम बताओ ना. This burden should be on you. There should be a presumption. Now the claimant need not be seen as an accused in adversarial proceedings as per the UN Declaration on Justice to Victims of Crime and Victims of Abuse of Power. His victimization is because of your abuse of power. Therefore, he is a victim, not an accused. He is not a claimant. It is you who should have the burden to show that I was not wrongful in my actions. तो इसको रिवर्स करिए, रिवर्स बर्डन. आप रिवर्स बर्डन काम कर रहे हैं ना? The burden should be reversed. Therefore, the third thing on the thought discourse is that you have used wrongful prosecution means malicious prosecution. अरे बड़ा क्लेवर है भैया, आपने पहले malicious prosecution, आप लोग तो बहुत चमत्कार करते हो. क्या आपने malicious prosecution डिफाइन कर दिया. malicious prosecution ने लिमिट कर दिया सिर्फ वही wrongful prosecution, और फिर कह दिया wrongful prosecution means malicious. जब करते हो आपने तो सारा का सारा निकाल दिया. बहुत से अधिकतर wrongful prosecutions, malicious prosecutions नहीं होंगे. क्यों? आप दिखाओ मेलिस था कि नहीं था. अब वो मेलिस दिखाने के लिए बर्डन उसके ऊपर है. Now how will he do it? वो अगर इतना ही सक्षम होता तो 23 साल जेल में बंद रहता. अरे वो पहले ही वकील करके बाहर आ गया होता. Now he is inside for 23 years. Therefore, to be able to. And finally, the third part, which is, as I was impressed by an article written by a professor of English. Therefore, I say Delhi is a good place. and keep hold on to Delhi. I have moved away from Delhi and I regret. A English department professor, some Alok Rai, has written
He's the son
The
of,
Spy Who Wasn't.
he's the son of Hindi writer Premchand, if I'm not mistaken.
Oh, is it Alok Rai? Must be the youngest son.
Yes.
Earlier, the elder brother I know. Oh. Now he has, in his article, I'm now talking on silence discourse, third discourse, speech discourse, thought discourse, silence discourse. Alok Rai ने लिखा है, please permit me to read Alok Rai's few lines. Why am I paying a part of Nambi Narayan's compensation? But how much greater is the complicity of the people who man the apparatus? And yes, it is mainly men. The bureaucracy is necessarily complicit in the evil of an evil system. I am quite prepared to believe that the vast majority of civil servants are good people, but amongst them there must also be the people who are drafting the policies, fabricating false cases, writing and orders and attending to the paperwork of hell. These people are complicit. The second order in Nambi Narayan case, the committee will not be able to find anything unless you go deep down into the system itself. What is happening? Why people, urban Naxals are being created? Why people are being labeled right, left and center? Now that is the problem. Because it is some people who are happy. And unless you make them accountable, unless you go down in the complicity street, you will not be. But this is part of discourse on silence. And this discourse remains silent, and that is the tragedy of our society, a brave society, otherwise a great society, truth-loving society, Gandhi's society. Tomorrow is Gandhi's birthday. How many of us would like to break the silence of non-speech? We must speak loud. Thank you very much.
Thank you, sir. Very enlightening speech, thought, and silence. I think. Mr. Colin is with us. He again doesn't require any introduction. And I really somehow insisted too much today. I'm sorry, really, because he was not feeling well and he was.
No, he's all right. He's all right.
But I said your voice must feature in this discourse because you are otherwise making a lot of voices on all these issues. And let us have the benefit of your presence today. And I thought we'll definitely like to hear him. And thank you very much for sparing some of your time. And floor is yours.
Thank you, Professor Bajpai. Actually, I was running a temperature, but I listened to Professor B.B. Pandey very carefully. And I tell you, he never ceases to inspire. Never ceases to inspire. And he doesn't compromise, he doesn't speak in soft tones, and he says things as they are supposed to be said. And I must say, I'm quite much better, as he said, particularly after his talk. I'll be very brief, because I'm intruding on somebody else's time. I'll be very brief. I read the report this afternoon. I think Professor Bajpai, you sent me the soft copy, and I looked through the report. And I must say, it is a very disappointing report. And it's typical of the reports made in India, where you have lot of case law, lot of general stuff, lot of international stuff, lot of history of the earlier commissions and all that. But when you look at the main topic, which is wrongful prosecutions, you find very little. And I think somehow people in power are so remote from the conditions of people, so remote from the realities of life, so remote from the kind of prosecutions going on in India, and certainly very remote from Chhattisgarh, Jharkhand, West Bengal, Orissa, Srinagar, totally remote from how the prosecution agency works. That in a long report of this kind with 130-40 pages, you have no mention of the core of the spread of wrongful prosecutions in India. First, it might be better if you were to have less high-ranking people and more practicing people, practicing activists, practicing lawyers who defend people. Because they will tell you in one conference, if you have a small meeting of half a day, you will get all the material you require for wrongful prosecutions. What is the core problem? The core problem is that our police force has become a criminal force. And you have an increasing larger and larger number of policemen in uniform who have turned out to be hardcore criminals. And they have tested their might against the judiciary by making all kinds of what I call fairy tales, all kinds of fanciful charge sheets, all kinds of fanciful FIRs. And they have done this experiment particularly in the conflict zones. So you go to Chhattisgarh, you'll find it. You go to Orissa, some parts of Orissa, you'll find it. And in Srinagar, you will definitely find it that he's a member of a militant organization connected with USB, which is linked to HKY, who is in Dubai, who wrote to Saudi Arabia, who sent a letter like this, and you'll get all these stories. They are very good fairy tale tellers. Now they've got away with it, and they've got away with it for many, many years. They write the charge sheets. The magistrates don't intervene at the early stage. The sessions court don't look at the papers at the early stage. And the matter will be said, you'll be told, accused will be told, go for trial. And that's your death warrant really. When you say go for trial, it means 6, 7, 8 years, particularly in a terrorist offense. You're away for a very, very long period of time. And one of the main deficiencies is the unwillingness of the court in the first instance to carefully look at the charge sheet, look at the 161 statements, who are the witnesses against you, and to make a guess, make a kind of a assessment as to whether this case is a totally fictitious made-up case or whether it is fit to go to trial. And it's become now the custom, everyone will tell you to go to trial. So if you make up a decent enough story and you have nice fictitious witnesses who've given so-called testimonies, the man will go to trial and spend the rest of his life in jail. If you see the Punjab cases that came to court, where KPS Gill and his people killed many people in cold blood, all the stories were beautifully written. The charge sheets were beautifully written. They were all terrible terrorists. After the Supreme Court said, CBI, go and look at those charge sheets, go and look at that evidence and tell me, are these cases really genuine? The CBI filed a series of charge sheets against the police, the Punjab police. And if you read those charge sheets will tell you how the Punjab police fabricated charge sheets, fabricated statements, fabricated seizure of weapons. These weapons were in the custody of the Punjab police, and they showed them as recovered from the person. When they went and met the witnesses, simple thing. They just summoned some of the witnesses. They say, in this statement of the Punjab police, it is said that you saw the man killing somebody and running away. Is it true? And the man said, sir, I was never even questioned by the police. I was not there at that time. So the fabrication of evidence on a very large scale. We saw that again in the Armed Forces Special Powers Act cases. Where 300 army people have virtually committed a mutiny against the Constitution. Where they come and say, this is all totally wrong, we are being subjected to them. Subjected to what? It is the CBI which is investigating them. It is the CBI which is filing charge sheets. And the first charge sheet filed, and that officer came to court with his whole unit. Some 300 officers signed it. He is found to have caught a 12-year-old boy who early morning was reading the newspaper to his grandmother. Grandmother's eyes were weak, so he was reading to her. His name was one Javed. Maybe they were looking for some Javed. They came into the house, got him by the collar, asked him, "Is your name Javed?" He said, "My name is Javed." Took him down to his garden, shot him dead, threw an 88mm pistol next to him. Finished. And like this is not one story. There are something like 1,500 stories. The High Court found 40. All the 40 cases that came to the High Court, all fairy tales, that they were fake encounters, murders in cold blood. The Commission of Inquiry set up by the government itself found everything fake encounter. And the Hegde Committee, which looked at 6 cases, found everything fake. And the Hegde Commission also concluded that all these people were supposed to be from dreaded terrorist organizations. And they have lovely names, very imaginative names, something that all X, Ys, and like James Bond, some kind of special code numbers. And Justice Hegde concluded not one of them is a genuine encounter. They're all fake encounters. And not a single person is a terrorist. In fact, not a single person has a criminal background. This is the nature of fake prosecutions, malicious prosecution, false prosecution. Done by a police force, which are criminals in uniform. Not the entire force, but substantial sections today of your police force are criminals in uniform. Now, one would expect that if that is the nature of false prosecutions in India, particularly in sensitive cases, UAPA cases particularly, Tada Pota earlier, that this report will cover some of it and say that in false prosecutions we must actually discipline our officers not to succumb to this tendency to make these fanciful stories and keep a person tied up. Akshardham case, Professor Pandey told you about the decision of Justice Gowda. He said everyone is false. The real ones have escaped. But will there be a judge in this country who, when they get a case like this, will there be a single judge in this country who will say, in view of my findings on false prosecution, in view of my findings, register an FIR against this investigation team? Not a single judge. From the bottom up, not a single judge will turn around and say, register an FIR now against the police. The man is out. And Professor Pandey also told you that on compensation they are not willing to speak. And this whole thing is full of some compensation case law and all that. Lovely case law. In India we have lovely case law. But if you read the end of the judgment, beautiful language, high sounding principles. You look at the end of the judgment and see they've given you 50,000 rupees. 5 lakhs, 4 lakhs, 3 lakhs, 2 lakhs. Murders in custody. Justice Kirpal sitting in the NHRC gave the Punjab people who admittedly were killed in cold blood 2.5 lakhs. After 20 years. So if you count interest and all that, he must have given them 4 or 5 lakh rupees. Why? Why not 1 crore for killing? Why not 1 crore for false imprisonment? We are in the period of globalization. We're not in the old period of the 60s and 70s. Why don't you give 1 crore? You destroy your family. Your wife gets mental illness and out of stress. Your children are pulled out of school. Your grandparents died because they didn't get treatment and you're rotting in jail. And you give a man 5 lakhs? Why not 5 crores, I say? Why not 5 crores? To make the life again of that person, to try and make the life of a person whole once again. So compensation again is a bogean. Compensation means I'll ignore the false prosecution. I won't tackle the evil of false prosecution, but I'll give you some pittance. And you know that the police of all the states, they have a special kind of a fund, special fund, which is meant for paying compensation for people who died. I think they must be calculating at 5 lakhs. So when they make their budget, they budget for killing, say, 20 people in the state in a year, 40 people in the state, and they put it in their budget that for killing 40 people, we may be asked. That is, if he goes to court and he gets a court order, we may be asked to pay, so we'll keep a budget for it. So it's now integrated into your budgeting system. Killing of people in cold blood is integrated into your budgeting system. There are 3 or 4 other points. I'll make them very quickly in respect of false prosecutions. And the first thing is meeting during the remand period. In 24 hours, you are to be taken before a magistrate. And in the period when till you are taken before the magistrate, you're beaten mercilessly. You're beaten mercilessly, your signature is taken on blank pieces of paper and all kinds of, your fingerprints are taken to be used elsewhere and all kinds of things happen. Anyone who complains to a magistrate will be taken like a joke. The magistrate will say, everybody tells me that. Everybody who's accused, everybody who's arrested is telling me the same story. I don't understand. He's telling you that he was beaten in custody mercilessly and you don't register an FIR against the police. So the police have become immune nowadays. First of all, they threaten the person that if you talk to the magistrate, he's not going to listen to you in any case. And secondly, if he has the courage and he tells the magistrate something, magistrate will say, chalo, take him out of the courtroom quickly. You are telling the magistrate something so important that you were beaten in custody during the remand period. And yet the magistrate will take it very, very casually. So the system has become dehumanized, desensitized, dead. Totally dead. Now you look at legal aid. Long back, there's a judgment, I forget, Professor Pandey, you'll remember. Legal aid from the point of arrest. Very important judgment which remained like that for I think 3 decades, 4 decades. Bombay High Court looked at it in Shabnam's case and said, the moment the police arrest, you must phone the local bar association. And the bar association must have a roster, it will send a lawyer to the police station. And that lawyer will be with you until the remand is made. He'll be in touch with you until the remand is made. Legal aid from the point of arrest. A very, very important provision, which would get rid of some of the torture that takes place in the police stations and so on, to some extent, that you have a lawyer from the point of arrest itself, but not followed. And now even in the Bombay High Court where that order was made, even there in Maharashtra, these legal aid provisions are not being followed. Legal aid from the point of arrest. Then you have, of course, this under trials issue which has come in this report quite a bit, where you have 200% overcrowding of jails. And the solution is not the making of new jails. The solution is to discover the flaw, which is now well discovered, that people are there who ought not to be there. At least half the population, as far as Tihar is concerned. Together with the prison superintendents, we have done a calculation of how half the prison population can be released in one go. Disabled persons, women with children, first-time offenders, young offenders. 107, 110 cases, people arrested on suspicion. Where in Madhur Limai's case, the Supreme Court says you should never arrest them in the first place. Hundreds are being arrested. It's an extortion process. You catch a person at night, he's a laborer going home after the third shift. You will catch him and you will take money, take money, take money. And the man who can't pay money will put him in jail. Hundreds across the country. Perhaps thousands across the country, tens of thousands across the country put in for 1 week, 2 weeks, 3 weeks on suspicion. Therefore, there's a clear case, and it has been a clear case for a very long time, that you can release half your prison population easily and achieve your purpose, that to get them to come back when the trial begins and so on, but they rot in jail. And that debate is going on endlessly. Every seminar will give you the statistics of under trials. India has the highest under trial population in the world, 70%, 60%, 80% and all that. And this report is also full of that, but no solution at all. So no solution on legal aid from the point of arrest, no solution on unnecessary arrest, no solutions on beating in the remand period, no solutions on anything. Then one or two things I'll just say. Now, we have done a series of cases also from different jurisdictions, and we've collected some kind of judgments. And you will find so many judgments of the trial court, so many, not a shred of evidence. And I want to end on this point, because we often make a point saying that the conviction rate is very low, 20%, 30%, whatever. We miss the point when we say that the conviction rate is low. And how do we miss the point? Because when police, particularly in terrorist offences and sensitive cases, arrest you and give a charge sheet in court in the specific period, they have no intention of getting a conviction. It is not the intention of the police to get you a conviction. It is not the intention of the police to cover evidence, gather evidence, make a nice charge sheet, keep the witnesses ready, leave the evidence properly, and get a conviction. Why should they do that? When, without getting a conviction, they can keep you in jail for 6-7 years. If the system is so flawed that even on a fairy tale, you can get a person in jail for 6 years and 7 years, and then ultimately the trial court will say there is not a shred of evidence against him. There is not a shred of evidence against him, in case after case. you know that the system is designed not to get convictions, not to do justice. The system is designed to keep people whom the police or the state consider undesirable, to keep them in as long as possible. Now on that, which is a major trend again, there is nothing in this case, in this report of the Law Commission. And this is false prosecution at its best. And we have seen it, and we have seen it in case after case after case. And so, Justice Deepak Mishra was wrong when he said it is difficult to find out how do we do it, it will open a Pandora's box, etc. Once a court gives a judgment, it's not a shred of evidence. It means that at the starting point, at the very beginning, generally, not necessarily, that the case was so flawed, the witnesses were so made up. You didn't have a case at the beginning and you kept the man 6, 7, 8 years in jail. Therefore, my dear friends, on prosecutions and false prosecution, we must focus on the police really. The question is, how do we catch our police people? How do we do charge sheets against them? How does the state have a special wing for prosecuting policemen who are criminals in uniform? Nothing matters. When you look at rape and handling of rape cases, violence against women, SC/ST atrocity cases, you come down to the root of the problem again and again and again. That you have a police force which is a thoroughly trained criminal force. Thank you very much.
Thank you, Mr. Kohli, for your reports, very critical reports, and in fact, this is something based on our day-to-day experiences. But you have, pointed out lots of things in the report, and I think all these points need a lot of attention, and at the end, we'll discuss it more. But what we are trying to find out whether can this report provide some kind of solutions to the problem that we are having in terms of suggesting the amendment that you are trying, to what extent that arrangement is going to be functional. All those are very critical issues, because there has been some beginning that has been officially made now. Because Law Commission is the authority to recommend the change in the system and the suggested. And let us not forget the spirit of the judgment that Justice Muralidharan and Justice Mehta gave, and they wanted, in fact, that framework to be prepared, and also those issues which were the part of that judgment to be really reflected in the scheme. Now with this I move on to Mr. Siddharth, and again I profusely thank him for taking his time out, because he has been traveling more than several thousands miles today, coming straightway from Kolkata just to join. He was busy with some case, but since morning he's texting or calling that because I thought it may not be possible for him now to travel back. But I really, appreciate your commitment, and today you are with us, because he is mentioned in this report, but he has his own position to explain on that. So over to you.
Welcome.
Thank you, Professor Bajpai. When I listened to Professor Pandey, it reminded me of the days when I was a student. I want to be a student again. He doesn't keep me now. And a time when academics would sit and tear up works by the government, works, judgments of the courts, firmly, specifically, and to the point, and we would all listen. And we would, I think, as Justice Murali said a little day, we were perhaps a little more tolerant in those days. I was briefly, and I must say this briefly, Fernando's part of the consultative process in this, but not beyond that. I think I agree with Professor Pandey. The report is the start of a conversation. Different. There is a balance between the victim's role and the accused role, which we all have to see. Now let's understand how, and I'm going to just raise a few random thoughts. How does the criminal justice system or the investigation affect you? It affects you first.
even before your detainment, you're called for investigation. There's a 41A notice, there's a lookout circular. And I must say this, I mean, I defend these sometimes I attack them, and on the day when I do both together, I get laughed at in court because which arguments do we take which side. So when a lookout circular, and if you know that that's under the rules, it's an administrative order, gets issued, your liberty is curtailed, you can't travel. You get a 41A notice. You are apprehensive when you go to the police officer, you may be arrested. What about that? What about the fact that you are wrongfully arrested? What about the fact that you are kept in custody? Brinda and others moved the Supreme Court, got an order of house arrest. There was a lot of cheer. I was wondering, I said eventually it's only house arrest. It's great they're not in custody, but they're not selling liberty either. Now let's not talk about what's happened there, but there are serious concerns about how the system operates, because there's a very greatly ignored judgment of the Delhi High Court which said on each date of remand you have a right of bail. K.K. Girdhar's case, 1988, 3 crimes, and it says you have a right to get. You know what happens in a remand application? Let me tell you what happens in a remand. Brinda's done some trial court work in the old days before she became the superstar that she is today.
I still go to the trial court. I'm not somebody else.
Before you became the superstar that you are, let me compliment you. Brinda, remember, I only compliment you. You're the one who gets after me, I'm only complimenting you, that's why we are friends.
It's the job of the citizen to go after the ASG.
I am not the ASG. I am has been, and Brinda refuses to treat me as a has been, which is alright. Sometimes I feel a little important when she pulls my leg. Now, that's the advantage of having old friends on the dais and dear friends. So when you, let me explain to you how it works, and Colin has spoken about briefly. You go to the magistrate at 2 p.m. The courtroom used to be in the old days 1/10, 1/8 of this room. You would stand there just trying to get what? To get a vakalatnama signed. Just to get the authority to represent your client. You're sweaty, you're hot, and the next thing is you say, what do I want? You write out an application, and my handwriting has never been very great, but you write an application asking for what? That he can carry his spectacles, that he can carry his medicines. These are the rights that you need to struggle for. You carry out, you try and tell the judge, a case is not made out for remand. The CRPC is silent on why arrest should take place. It says 41A says a lot, but does it say enough? We have no concept of how arrests are to be made. It is the complete subjective satisfaction of the investigating officer until we have guidelines on when to arrest. We're going to have problems, and I'm sorry to say this. I have friends in the media, I have activist friends who scream for arrest all the time. Is that fair? Because that doesn't have a repercussion on that case alone. That has a repercussion across the board. So when you scream for arrest on the grounds of heinousness of an offense, great. Is it going to achieve an investigative end? Is it otherwise justifiable to support the investigation? These are serious concerns that we need to address within the system, because what's happening is the first point when you lose your liberty is arrest, and wrongful arrest. We've been told once the arrest is confirmed by a judicial order of remand, you can't even have a habeas corpus. Kanun Sanya. So where is the right that you get? So you're arrested, you're remanded, and then you can't be touched. The law plays that way. Though even if you're on bail, you have a right to move habeas corpus, but who listens? Try asking then a magistrate. Police custody, yes, magistrates, look at judicial custody. It's now done on video conferencing. The person is not brought to court because of administrative convenience. I'm telling you, even as a prosecutor, I feel this pain because it's unjustified. On the rare occasion that I still continue to prosecute, but it's unfortunate. The person has a right to come to court unless he's ailing or otherwise, to meet his family members, to see what life is outside the system, to give whatever instructions. You do it on video conferencing, it's convenience, yes. But what are we achieving? What we are achieving really is that the magistrates and the judges are doing it absolutely mechanically. At that stage, though I have a right to ask for bail, I'm continuing in custody. Unfortunately, the report doesn't deal with arrest effectively, nor does it deal with remand and wrongful remand. I get exonerated when there is a finding. There's a 1960 judgment, Vadilal, which said even the general defenses, even the defenses can be seen at the stage of a police investigation and even by a magistrate. So a man says, or a woman says, I was in London when the offense took place, and I'm using the example of London because it's far enough in a way, it's not within the country, otherwise they would say, they would triangulate and say we are within Delhi somewhere or the other, I had a different phone, but let's say I'm overseas, so there are passport stamps. Murder takes place in Delhi, I'm prosecuted in Delhi, eventually the police find after keeping me in custody 60, 90 days later, I'm not to be prosecuted, I'm dropped. There's a magistrate at that stage taking cognizance. Isn't that the first checkpoint in a criminal prosecution? Summoning, second checkpoint, sometimes by and large is the same. Third is charge or discharge, and fourth is acquittal. The moment a magistrate or a judge exonerates you or accepts a closure report, should he not be entitled to say, this is a case of a false prosecution or a malicious prosecution? I'm going to deal with those two terms in a little while. Should I not be allowed to give compensation here and now? Why should I have the accused who suffered enough move? Let me give you an example, and I'll tell you two examples disparately. One I was for the accused, one I was for the state. There is an old case, perhaps Brinda, your father did it, if I'm not mistaken, 96, where somebody, I think it's called DGF, and I think your father done it at some stage, your late father done it, one of our most eminent lawyers in Delhi. This person gets stuck in Antiquities Act, they got exonerated, and gentlemen filed some malicious prosecution case. Finally, the malicious prosecution case came moving. I was a law officer, they came to me, I said, you've come to me 16 years late. There's a high court decision, how am I going to do something? I said, anyway, let me try. So we tried, and I managed to get a notice from the Supreme Court. Incredible. On the other hand, there was a client of mine who got off, exonerated at trial court conviction, at sessions court acquittal. High Court had said, it's not a case made out, interpreted, the customs circular said there's no offense. What happened? Her husband, against my legal advice, against my well thought out legal advice, not to file malicious prosecution and damages, insisted on doing it. The moment they did it, SLP filed, it gets Justice Nariman, then he was the Solicitor General, he appeared, got admitted, it got done last year. And what did the Supreme Court do? The Supreme Court said, you know, everything is also alright, but these allegations of malice against the officers is not right. So the suit falls back. There are so many examples that one can give you, but let me tell you what the problem seems to be. First of all, I think one of the fundamental issues, and I agree with Colin here, is there is a concept called practical policing. I speak about this very often. Practical policing is how records are maintained and kept in police stations. When your general diaries or station house diaries are going to be finalized at the end of a 12-hour session when the person is going off duty, you're going to have serious aberrations because everything is being generated and created for the purpose of filling in the gaps. That's a serious problem. There is a serious issue on the nature of training police officers are given. I've been to the police academy where constables are trained. We're much better now than it used to be, but it used to be horrendous 20 years ago when I started going there. The media wants arrest, the media wants conviction. My former junior from my former college wants the nation to know that he must convict everybody every evening. We shall not take his name. I don't think you'll have difficulty guessing. But if that's the kind of pressures that are put within the system, how are we going to expect a fair trial for anybody? Now, I have, another serious concern, and I'm sorry I'm going on and on. The Supreme Court in decades after decades has whittled down the procedural requirements of searches, seizures, arrests, everything has been treated as irregularities, non-material irregularities. For heaven's sake, criminal law, Article 21 is all about procedure. if you don't give any sanctity to procedure, where are we going to have a fair trial? After all, it's the processes that help you. The second thing that needs to be done, and I'm sorry I'm digressing and I'm going on, is there needs to be a serious revamp between the police rules, between the High Court rules. Who looks at the High Court rules? I remember in my own career, sir, I showed an honorable magistrate who's now a session judge, a batchmate of Vrinda's. I will not take her name. A friend and a batchmate who
I
was
guess.
Vrinda. No.
The friend is your speculation.
No. You're all friends. Vrinda, listen. I treat you as my friend. You may not, but that's a
The
different
friend,
issue.
it wasn't addressed to you anyway.
No, I'm just teasing. I'm just laughing. But no, on the lighter side. And I remember, sir, in the New Delhi court telling a magistrate, madam, you need to sign the case diaries because that's the way we will secure that there is no tampering with the investigation. I was asked, what are these High Court rules? This is a magistrate in Delhi, 1.5 kilometers from the High Court. Fortunately, there was another magistrate, Justice Bansal's daughter, who happened to come in at lunchtime, Nina, and Nina told the person concerned, listen, these are High Court rules, you need to act on this, you can't ignore them. And fortunately, the case diaries got signed with a lot of reluctance after I was practically called all kinds of names in the court as if that I was misleading the court. Now, this is a fundamental right. Magistrates are supposed to do this. Magistrates are supposed to see remands. Magistrates are supposed to see whether a person should get bail. Not saying bail bonds for verification for 4 days. So I will say this. I think we need to have a relook. Use this as a starting point. Examine the desirability of a compensation stat at the point when the investigation, at the point of wrongful arrest. Alright, if not wrongful arrest, definitely at the point when the charge sheet is filed or the closure report is filed. The court is seized of the matter, the court sees the record. Why do you expect the accused or the erstwhile accused, now an honorably acquitted person? Because after all, last I heard we did have a presumption of innocence in India. I don't think it exists now, but I believe it, on paper at least it does. Now if the presumption of innocence exists and it is reinforced by the fact that the police have discharged you by filing a closure report, the magistrate who seized of the matter, why should he not grant compensation on consideration of the available materials if A, it is a case of malicious prosecution, or B, it is a case of wrongful prosecution, negligent prosecution, and I would have wished the report would have used the word negligent a few more times. Secondly, discharge, the same consideration. If you missed it at the first stage, you find at the strong stage that it's a bad prosecution, you have to tell the person you suffered for years, why are you suffering? You know, a few years ago, a friend of mine was here, she's a criminal lawyer, the master of Fitzwilliam College, Nikki Padfield, and she asked me a question. She said, Siddharth, what are the budgets you have for things like criminal justice? You know, unfortunately or fortunately, we're very flexible. So if we need money, we will have all the money. And sometimes when we need it, we don't have it. Now, if that's the situation, if we don't lack the money, is the fact that compensation is going to be granted a consideration at all when we are interfering with human rights? Similarly, at the case of honorable acquittal, as they call it, baizat bari as they say, it's a no-brainer. Look, let me tell you a very fascinating thing. So, an accused who is prosecuted can lose the property which is the subject matter, because the property that's the subject matter can be taken away at that stage and the court can make an order for it. Surely the court which is considering should also be empowered to make an order at that stage for compensation and immediate compensation, interim or otherwise. So broadly, as I said, these are the points that I wanted to make, but there are two things I want to say. I would say wrongful needs to be said, relooked at as something which is without legally usable material or admissible material or evidence. And I'm saying this because I have come across so many charge sheets which are filed on the basis of photocopies, there are no originals. We ask for inspection, after 6 months later we find out when we inspect the record now in the area, in the time of electronic records in 140,000 pages charge sheets, it's difficult to even verify the record because you're given an electronic copy. When you verify it, you discover that there are only photocopies. Can you charge a person based on photocopies alone when the originals don't exist? So that's what I mean by unusable material or inadmissible material. I have a lot to say about how 65B is being interpreted because that's another horror story, but we'll leave that for another occasion. Secondly, the maliciousness, deliberately, for extraneous reasons are the terms that need to be introduced. If you prosecute somebody deliberately or for extraneous reasons, you have to pay compensation. Depending on the stage, depending on the harm caused, my view, compensation must follow and immediately. Otherwise, the injustice we are doing to our citizens, to individuals who come to this country, is unimaginable. Thank you.